Have you ever wondered about the legal complexities when a spouse, once declared presumptively dead, reappears? Today, we'll delve into the fascinating and often surprising legal consequences of such an event. Welcome to our video on spousal reappearance and its legal implications. This topic, governed by the family code, is crucial for anyone navigating marriage and legal declarations of death. What exactly happens when a supposedly dead spouse makes a comeback? It's not as simple as it sounds, and the law has specific provisions to address these unique situations. The legal consequences are primarily outlined in Article 42 of the Family Code. This article serves as the cornerstone for understanding the effects on subsequent marriages and the original union. Under Article 42, a subsequent or second marriage is considered valid until it is legally terminated. This provides stability for the new union, but with certain conditions. For the second marriage to be valid, it must have been entered into in good faith, meaning both parties believed the first spouse was genuinely dead, and a judicial declaration of presumptive death must have been obtained. So even with the reappearance, the second marriage doesn't automatically become void. It remains valid until specific legal steps are taken to terminate it. However, this second marriage is automatically terminated upon the mere filing of a sworn affidavit of reappearance by the rediscovered spouse or any interested person. This affidavit is a critical document. It can be filed by the supposedly dead spouse or any interested party and must be duly recorded in the civil registries concerned. The act of filing and recording this affidavit is what legally terminates the second marriage, making way for the first marriage to be reinstated. Now let's look at what happens to the original marriage. This is where things can get particularly intricate. Concurrently, the first marriage is reinstated or revived once the affidavit of reappearance is recorded, essentially undoing the effects of the presumptive death declaration. There are exceptions, of course. If the first marriage had already been legally annulled or declared void before the affidavit was filed, then it cannot be reinstated. What if the present spouse wishes to maintain the second marriage despite the reappearance? There's a legal path for this, but it requires swift action. The present spouse has the option to secure an annulment or declaration of nullity of the first marriage before the reappearance is recorded. This proactive step can change the outcome significantly. This action is necessary because if the affidavit is filed and recorded first, the second marriage terminates and the first one is reinstated. Annulling the first marriage beforehand allows the second union to legally subsist. Finally, let's consider the fundamental purpose behind the legal declaration of presumptive death. The declaration of presumptive death serves the legal purpose of allowing the present spouse to remarry without committing bigamy, providing a path forward after the long absence of a spouse. It offers a protective legal framework for the subsequent union, ensuring that the new marriage is recognized and has legal standing, at least until any reappearance complicates matters. In conclusion, the reappearance of a supposedly dead spouse is a legally complex scenario with clear guidelines. To recap, the second marriage is valid until a sworn affidavit of reappearance is filed, which then automatically terminates it and reinstates the first marriage, unless the first was already annulled. Understanding these provisions from Article 42 of the Family Code is vital for anyone facing such a situation, ensuring legal clarity and protection for all parties involved.